family tree information. So if you have a loved one that signed up thinking this is going to be great, they could have put information in there about you without telling you, and that all got collected too, and they got your phenotype. After that, they would take your spit sample that's actually in a little vial and stored somewhere now that actually got sold as well, and they would print out your genotype and give you your results. And so they have all the normal stuff that we consider PII, plus they have your actual spit, so solid DNA, they have DNA reports, and then they have Lemonade Health, which is a health company that takes your genotype and gives you specific health information based upon the test 23andMe did. Guess what? HIPAA does not apply to them because they do not take insurance. So that was up for sale as well, and I'm not going to talk anymore about that because we're still dealing with it. And so there's just a lot of information that wasn't protected, and I think there was a lot of information that nobody ever thought would be sold, and types of information. And so the states came in and we wanted a CPO, and I think we had a coalition of about 30 states that said we needed a CPO. Debtor wanted to have their own CPO. Like I said, we ended up agreeing to have a CPO appointed. He did a fantastic job. But issues arose as to, well, what privacy policy do you look at? We were all on the way back machine, going way back, pulling it up, and you would have some privacy policies that said one thing, we'll never sell your information. The one that Thomas finally said, we'll sell everything. I'm paraphrasing. And then you would have them linked to other documents. And so what is the privacy policy was another question. Is it just this one page you're reading, or is it a link to the terms of use? It is a link to this other document. And then if so, you have a stack of documents that nobody will read except me and maybe Elise. And so these problems arose, and there was some very creative maneuvering in the bankruptcy to where the final issue never had to be addressed under a sale of actual data. It was a sale of equity that happened. I can bore you with that later. And so we still don't really have an answer. This was okay. The AGs were able to negotiate safety protocols for the transfer of this data. And one huge one was this data wasn't actually going to leave the machine it was on. Lots of bad things can happen, evidently, when you take information from one machine and put it to another, or from the Amazon Web Services to something else. That's my extent of knowledge of how that works. That didn't happen, and that gave the AGs a lot of confidence that a lot of problems would not happen if it was sold this way. There was a whole litany of other protections as well. It's all in the sales document. But the question's still out there. If this was a sale, what do we do? And
was the buyer also not a for-profit buyer?
The buyer was Anna Wojcinski, who was basically set up a not-for-profit called TTM, which stood for 23andMe. And so she just rebought her stuff out of bankruptcy, turned it into a nonprofit, still runs the same website, still works the same, but now it's 23andMe Research, and it's a not-for-profit. And so same people, kept the same employees, kept the same computers. A likelihood that bad things would happen to your data was very low. But it still begs the question, where does genotypes and spit samples and voice recordings fit in bankruptcy sales? What are they?
I also think that 23andMe is slightly uniquely different than many other cases, like a consumer case, a retail case. My family did all of these. I stood over them and forced them to delete it because I didn't consent. And my data is in there by virtue of the fact that we're related. And what you do see statistically in a retail case when a sale is announced, even Radio Shack, which made, was the brunt of late night jokes and morning shows and huge discussion, you did not see an appreciable uptick in unsubscribes or people looking to kind of get out of the sale. 23andMe, though, is a totally different story. I think it crashed the server a couple of times with the unsubscribes, and I think that there was a significant opt-out. So it shows you where the pressure point is and where people care.
Yeah, absolutely does. And where people, including bankruptcy lawyers, aren't expecting it. I mean, when you sign up for 23andMe, not that you wouldn't expect that your DNA is going to be sold. Guess what? your voice recordings are next, this is going to just continue, so we should think about it proactively and figure out what changes should be made to make it a smoother
Great.
transition.
Great. I'll just say a final thing, which is that the 23andMe opinion is great. And I'm not saying these two agree with it, I'm not saying I agree with it, but it is a great opinion. Brian Walsh, who's the judge in that case in St. Louis, is brilliant and worked very hard. And so it is, again, right or wrong, it's a very well thought out opinion, really in the area where there just isn't a lot of case law in the statute.
I agree. I think he got it right for what he was dealing with, and I think it was very well thought out. 23andMe is on Kroll, and it's docket number 908. If you want to read the memorandum, you should. It's very well thought out.
Can you repeat that?
Sure. Kroll is the noticing agent, and it's docket 908.
Nice job. Yeah, man. All right. All right, we're going to switch topics now. So we're going to talk about the fishbowl and maybe covering up the fishbowl. So traditional bankruptcy principles emphasize transparency, which is consistent with the general norms of the judicial system. Proceedings are public, filings are public, and for good reason. It's important for parties to be able to contact each other for case-related matters, to be able to assess who might be allies or enemies, to be able to figure out the stakes of a given issue, contest, like the outcomes of various courses of action, voting, whatever it is, and just to build public confidence in the judicial system. So we could probably all think of many other reasons too. But the fishbowl commitment has come under some tension as information is so easily accessible to folks outside the case, in particular, who may have bad motives. So we're going to talk about kind of these are some emerging practices that I think judges and practitioners really need to be thinking about. And again, this is an amazing panel to have on the issue. So let's turn first to Sealing.
All right, sealing is a staple in most large bankruptcies, first day motions, and I agree with it. I think if you have a long list of consumers who have given you their data, home addresses, and you owe them money because they're your creditors for some reason, I think it should be sealed, subject to a legitimate reason for asking the court to have that list. And if you think about it, the mega cases get all the attention, but they're not the majority of the cases being filed. And so this isn't happening everywhere. And generally the people you're sealing aren't the public utility or the guy that delivers the toilet paper. It's individual people who have lives and children and should be protected from being out in the public domain when they did not choose to be. There are some examples. Well, first we'll talk about the Pier 1. Pier 1, they redacted home addresses, and they did have the ability, if you had a legitimate reason, to get the complete list. I know in the crypto cases, there were mostly sealed documents, but again, like 23andMe, the crypto cases was a very different type of animal. And not only were you putting people's names and home addresses out there if you didn't seal, you were also putting how much money do they have, how much crypto do they have, and that's putting a target on an innocent person's back, and that's wrong. And so you also get obvious cases. Boy Scouts of America, that's going to get sealed. That's just the right thing to do. But I do think you need a legitimate purpose to get it. One of the issues that arose in Charming Charlie's, I'm sure you're all aware of, is an employee had their name and home address listed. An abusive spouse found it and started harassing that employee. That's unacceptable. The employee didn't ask to be listed with a home address. The employee obviously had some very serious issues that should have been protected. So this is where the U.S. Trustee's Office and the AGs that I represent, we split ways because I understand bankruptcy is public. We're not going to hide anything. But I think that there's a balance between public and hurting people that did not sign up for this. I think when you do business with a company as a vendor, you're signing up for it. The business could go under. But if you're buying pants from JCPenney and you return something that didn't give you the money back, you probably shouldn't be listed with everything on. And so that's the position that AGs generally take is let's protect our citizens. It's not the majority of the cases. So
I would just suggest that on the creditor matrix, that debtors counsel think about it a little bit from the consumer perspective and what risks you're opening up consumers to by identifying them by name with an address. I mean, you know, I grew up in an era of the phone book being thrown in my driveway, right? And that pretty much had a lot of personal information in it, which is very different than what you can get on the claims agency. That opens up the transparency to courts so much broader because you can go one place and see all the affidavits of service, you can see all of the creditor information, the dollar amount of claims, not necessarily the underlying claim, but there's a lot of information out there that because in the first instance, debtors counsel decided to schedule that party as a creditor, that then I'm exposed. And I would just think about whether or not somebody needs to be identified so specifically at that stage without sealing the information.
I agree.
You know, it's interesting. I've been thinking a lot about this issue because we've been talking about it. I've been reading these documents that we've pulled from various cases. And some of those are in the materials, by the way, which I think do bear looking at. And some of the relief is very minor. I mean, like the Pier 1, I mean, it's just the addresses that are redacted, again, subject to being disclosed for legitimate purposes. Some of them are more protective. But I was on a call with a federal district judge from another district, and I brought this issue up, and I said, well, are there any analogous issues where you've been seeing this or thinking about this issue? The person really said, no. You know, this is not an issue that's on the radar at all. And so I kind of wonder, is this really a bankruptcy-specific issue where we're encountering, we've got these hundreds and hundreds of people on these matrices, you know, and obviously these extremely sensitive issues, Boy Scouts or the diocese cases. So it may be something that we in the bankruptcy world have to really kind of think about how to handle it, whether it needs to be pressure for new rules or whether it should just be a routine first day matter.
And the size of the case, I think, should matter too, because most sub-5s, mom and pops, this is something that can play, and generally they don't have a noticing agent. And I think lots of nefarious things happen, not because it's the noticing agent's fault, but just because there are hackers out there that'll go in, pull down orders. Literally, an order was changed by someone, and I think it was a Celsius crypto case, and obviously Judge Glenn had to handle that. And there were, I think, over 100,000 fake claims filed in the 23andMe case, over 100,000. And so, particularly if there's a noticing agent, I think sealing is very important.
You were describing the fraud in one of the crypto cases, right? They used information that was out there to kind of send out phishing emails.
Yes, and yeah, with different, with fake orders. But again, when the pieces are out there in the public, and you don't have to really look very hard to find it, because there are, you know, typically debtors have their website, committee has their website. There's a lot of sources of information. When you start data mining and putting it together, there is no privacy left, and it hits home when it's about you and your finances. So that is a unique issue, I think, to bankruptcy, because you're not going to have, other than maybe a class action where there's a lot of docket action, you're not going to have access to so much information in a district court case.
That's true.
It's unique to bankruptcy.
Well, and another thing, I'm gonna make up to 23andMe because this is I'm really devoted to figuring out the problem of where will our DNA fit into personal information in bankruptcy? Where will our voice prints fit in? Where are our fingers gonna fit in? We have those I don't have a ring. Folks have 4 rings. It's taking all sorts of information about you. This is going to continue. And in 23andMe, you would hear, oh, but this data is de-identified, which means you can have these genome reports, but it's not linked to any certain person. It can be re-identified very easily. So if you're selling de-identified genetic stuff and a customer list with all of the typical information in it, those can be put back together, y'all. De-identification does not protect you. So just a word out there. And if you are a loved one, cannot get your 23andMe data deleted, email the Debtors Council, and they've been sending you to the right places to get that done. They just mentioned that in court yesterday.
Okay,
So,
I'll follow up.
Christopher Hopkins.
This is really the purpose of the panel.
Yeah. So, just touching quickly on notice and transparency. I think that there are changes that could be implemented, but they're not the type of thing that are going to happen without some either clerk's office or judicial intervention. And things like, and again, I think claims and notice agents are a beautiful thing. They provide easy access. You don't have to sign up for case notices. You can leave when you're done with the case. You can see documents for free. It's great, but they're, are they data managers? But more importantly, are they putting consumers at risk by posting an affidavit of service on the docket that contains all of the email addresses and home addresses of every single potential creditor, right? Because that's the creditor matrix put together by the debtor. So what are ways that we can think about to be creative to make it harder for nefarious actors to gather the information, mine the data, and put people at risk? So that's kind of where I think we should be having conversations about, kind of going back to the old PACER system. If you want to see the affidavit of service, go pay your 10 cents a page.
Judges are here.
No, I think that goes to the question I wanted to ask, which is, go 5 years after the case is closed, and someone says, I never got notice. And all that we have on certificates of service is name not included. The case is closed. How does anyone prove who got service? Because what we're not getting are redacted service lists. We're getting, we're not seeing the unredacted service list. All we're getting is a redacted service list. So there is no record of who got served. How do you propose to solve that problem so that we have a record of who actually got service?
I'm actually surprised the court is not provided with an unredacted copy of that. I think that would not be a best practice.
Agreed.
I think that what's
Are
publicly
you
available.
over any court that's getting a service list that is redacted? Because I'm unredacted, I am not. When the claims agents are doing it, they are filing one on the public record and the names are gone and you can't tell who got served.
Well, I think the court should definitely, if something's getting sealed like that, the court or the U.S. Trustee's office should have an unredacted copy of it.
But that needs to be, in fairness, when we get the proposed orders, we can go and we can solve the problem.
Yeah.
No one is thinking of this problem, and I think you need to think about how to deal with it. Because if you're going to advocate for sealing, it's going to be fine with me. The problem I'm having is I then can't tell who gets served.
That's legit. That's a legitimate concern, and I'm sure it's not one that people were aware of.
Yeah, I think it's a great example of
Yeah.
why, some kind of rulemaking process would really be the ideal way of handling it, and at least to air these concerns. And, whether, again, that issue that becomes a formal rule or whether it's through a kind of set of best practices, I don't know. But that's the kind of concern that I think needs to be aired about this stuff. And I think it's not being, because it is kind of still this perception of it's case by case, and then I think nobody wants it to become a huge issue, and so this is our defense of the U.S. trustee who were criticizing on this issue, and you read some of the transcripts, and the U.S. trustee's advocacy for this is not always kind of wholehearted. It's unclear. They're kind of, but maybe that advocacy is useful in the sense that it will kind of air some of these concerns, and that's one of the concerns that
Again, if this is just a small case, I have to log into my ECF account and make an affirmative effort to obtain the information. If we went back to that for some of this sensitive information, I think it would at least slow down.
It would be a good start.
It would be a good start. I don't know what other solution there is, because you run the risk of not including somebody, as the judge just said, who is a creditor, and then how do you establish that they did or didn't get notice?
Well, I think we should get everybody in the room and talk about how to solve this. So.
Yeah, anybody who wants to go to the mic and we're ready for you. But I do think it's a question of whether it is just now, it's a routine matter, that with or without statutory basis. I mean, and again, with or without these kind of best practices shell surrounding it. So I think it's something that is worth talking about. I'm glad we've had the chance to do some of that today. We would love to hear more comments if you have them. Otherwise, Charlotte. Oh, Chris Hampton, yeah, please. Can you go to the mic?
So, I understand the set of questions for like a for-profit buyer or someone nefarious buying data. Has anyone thought about what would happen if the government tried to buy data? I don't even know if it's possible, it's coming from a place of ignorance, but let's say for law enforcement want to crack some old cases or find some people, I'd love your thoughts on that.
They do this, right? This is.
So my MGs don't do this, like, if presented with, do you want to buy this data, it's gonna be responding no. It's for now, I mean, people change. But I know that the police officers and people do use genetic formats, and I have no idea, honestly, because I have not been put in that position either. It would be an interesting issue, though.
I did think about Professor Hampson's work when we were talking about 23andMe, the fact that it was sold to a not-for-profit did make a difference, at least, again, I don't know legally speaking, but it made a difference in terms of who was able to come to an agreement about it.
It was. We had Regeneron on one side, and Regeneron was not similarly aligned with what 23andMe did. And to sell, they need to get a similarly aligned company. Had it sold to Regeneron, we would probably still be fighting about it, honestly. But since basically Ellen Wojcinski, who started 23andMe, took her family trust money and turned it into a nonprofit and then bought the equity of a drop-down company that they set up, that was different. We had been the states had been working with 23andMe pre-bankruptcy on a bunch of CIDs and investigations due to the data breach that had happened in October of 2023. And we knew the processes they already used. We knew what needed to be done to protect it. And so it was just a different situation that I do not think will recreate itself in another bankruptcy, frankly.
I don't think so either. I just want to give one practice point, which is when you look at a privacy policy, it tends to be you want to be as expansive as possible to maintain as much optionality as possible. So you throw in that you collect biometric, geometric, all these different data points. If you don't actually do that, it is going to hurt your sale because you're going to get a CPO. So you might want to think about whether or not you're being customer facing when you put together your privacy policy.
Now we have a question from the audience, and the question is it this moot, since it is most likely at least 10 countries have all of this, and it's on the dark web?
Yeah.
It is on the dark web. So unfortunately, in 23andMe, about 6.9 million people's data who signed up for it and didn't sign up for it due to them signing up for it and giving them their information without their consent, was hacked. And about 1 million, I believe, folks' information was actually targeted and sold on the dark web. And it was people with Jewish and Chinese descent. And that is just wrong. And that is one huge reason why so many states have been investigating them prior to the breach. And another reason why the states were very invested in making sure that after this bad thing happened, since it was getting sold back to the same person basically, this data had to be protected.
One of the interesting points raised by the Consumer Privacy Ombudsman was what to do about folks who have deceased since the time they gave their genetic data. And they meaningfully consent to it being transferred, even by opt-out mechanism. And, you know.
Well, like in Arizona, this is where we don't have a lot of federal law that actually